Hello and welcome. My name is Beverly Popek, and I'm a Supervising Compliance Officer with the Office of Labor Standards Enforcement, City and County of San Francisco. We're here to help you understand your labor compliance requirements. Today, this is a Fair Chance Ordinance overview, and it's going to provide you a quick starting point to understand all of the requirements for the Fair Chance Ordinance. As mentioned, this is an overview. We will not get into the details and best practices of the compliant hiring process. If you would like this information, which is also highly recommended, please see our FCO Employer Toolkit video series. This slide provides some background information about the Fair Chance Ordinance and other ban the box ordinances and legislation. As of 2001, 34 states and over 150 cities nationwide have passed some form of ban the box or fair chance legislation. Now, ban the box and fair chance legislation can be completely different from the San Francisco Fair Chance Ordinance. So if you are operating in different jurisdictions, please make sure you understand what the requirements are. In 2014, the City and County of San Francisco passed the Fair Chance Ordinance, and in 2018, the state of California passed the California Fair Chance Act. Now, stay tuned a little later. I'm going to point out some key differences between the state's Fair Chance Act and the San Francisco Fair Chance Ordinance. So who's actually covered under the Fair Chance Ordinance? If you're a company operating in the city and county of San Francisco with any employees working in San Francisco or planned positions in San Francisco, then you could potentially be, of course, a covered employer. If you have 5 employees or more anywhere in the world, and you have employees working in San Francisco or planned positions in San Francisco, then you are a covered employer. Now, how about your employees? Are they covered under this law? Any position where the employee works or will work at least 8 hours a week in San Francisco is or will be covered under the Fair Chance Ordinance. Now, we have San Francisco city contractors, and these are companies with a contract with the city and county of San Francisco. We have many different types of contracts, such as contracts for services, grants, leases. This is a standard provision in your agreement, your contract with the city and county of San Francisco. So for covered city employees, you just have to be any size and any employees that will work in San Francisco and are, of course, are working in San Francisco. In terms of the employees, if they're covered, it is quite similar to the previous slide. Any position where the employee works or will work at least 8 hours a week in San Francisco is covered under the San Francisco Fair Chance Ordinance. So what is the San Francisco Fair Chance Ordinance all about? It requires a compliant hiring process. Employers cannot ask about or inquire into convictions or unresolved arrests until after a conditional job offer of employment is made. We highly recommend that you take a look at our FCO Employer Toolkit to understand the process and to perhaps supplement the pieces that you might already have in place. And you can watch our FCO Employer Toolkit videos. That will really get into the details, best practices, and a lot more information that we will not cover in this video. So this slide is from the Employer Toolkit, and it gives you a good starting point to understand if the position is covered by the Fair Chance Ordinance. You just have to ask yourself one of the 2 questions, or actually both questions with the boxes up here. The first question is, do you have 5 or more employees globally? And the new or promotional position is for 8 or more hours per week in San Francisco. If that's you, you check it off. Second box is, are you a San Francisco city contractor? And the new or promotional position is for 8 or more hours a week in San Francisco. If that's you, you check it off. And quite simply, if you checked either option, the position is covered and you must follow the steps that's in the flow chart document in the FCO Employer Toolkit. So the first step that we're going to look at is the job posting, application, and interview. Keep in mind that your job announcement must have a compliant language that says that you will consider qualified applicants with arrest and conviction records for employment in compliance with the Fair Chance Ordinance. In our toolkit, we have some suggestive compliant language. We also have this information on our FCO webpage. In addition, when you get to the examinations or the job interviews, please keep in mind that you cannot ask about the applicant's history of arrests or convictions. And this includes statements like, will you be able to pass a background check? You can't ask that. So now that you understand very quickly the overview of what you should definitely do and not do, let's take a look at step 2 regarding when can you run a background check. You can run a background check if you'd like, but only after making a conditional job offer to the applicant. Once you run the background check and a report comes back, you must conduct an individualized assessment of the applicant and consider the 3 items that we list here. Number 1, the criminal conduct and how it's directly related to the person's ability to do the job. Number 2, how long ago the criminal conduct occurred, and 3, evidence of the applicant's rehabilitation and other mitigating factors. So that's the really high level of what you should be doing in an individualized assessment. Our toolkit provides you a form that would really dive into it and can offer you a great assessment package for you to use and to supplement with perhaps what you're already using. Now, keep in mind the very bottom of this particular slide, there are things that you can never ask or consider. And it's okay if you don't understand what these terms or words mean right now. This is written down. And what I would say is that you can look up the definition of these terms, but keep this list on hand and remind everyone in your company involved in the hiring process, especially if they're speaking or communicating with the candidate, that you may never ask and consider the following. So, for example, the first one here is an arrest not leading to a conviction, except under special circumstances identified below with respect to an unresolved arrest. The second item is participation in or completion of a diversion or deferral of judgment program. 3, a conviction that has been judicially dismissed, expunged, voided, invalidated, or otherwise made inoperative. Number 4, a conviction or any other determination in the juvenile justice system or information regarding a matter considered in or processed through the juvenile justice system. Number 5, a conviction that is more than 7 years old and it's measured from the date of sentencing. And lastly, a criminal offense other than a felony or misdemeanor, such as an infraction. So, step 3, can you take the conditional offer back? And the answer is yes. And also keep in mind that every company is using a company to do background checks if they are doing background checks. Don't assume that the background check will filter out all of the information that I just mentioned. So you must be aware of what the San Francisco Fair Chance Ordinance requires and says that's off limits. So as you read the report, keep that in mind. So if you do want to take back the conditional job offer and you review the criminal history and you've conducted that individual assessment and you don't want to hire the person, you must let them know, and you must let them know in writing. And you have to give them a copy of the background check, a bare minimum, and at least 7 days to respond with clarifying information if they would like to clarify or provide any other information for you to consider before you make your final decision. So the San Francisco Fair Chance Ordinance requires you to give at least 7 days for the applicant to respond. The state law at bare minimum only requires 5 days. So if your company is in compliance with the state law, you're probably only allowing 5 days for the applicant to respond, which would make you in violation or not compliant with the San Francisco Fair Chance Ordinance. So how these laws work is that the most generous law, such as in this case, if you look at the San Francisco Fair Chance Ordinance, is requiring 7 days. If you were to follow the San Francisco Fair Chance Ordinance with allowing 7 days, you would be in compliance with your state requirements for the state of California under the Fair Chance Act. So that's something to remember and something to review in your processes. Now, the next item is if the person submits new information, you must conduct an individual reassessment. Now, you've already done an assessment and you've kept that information. Now you must conduct an individual reassessment based on any new information that the person is sending you. And in our employer toolkit, we have a form that you can use to see how to conduct a reassessment. And then finally, if you still and you decide your final decision is to revoke the job offer, you must send a notice of final decision to revoke the job offer. And in our toolkit, we have a sample letter document for you to see what that can look like. Now, there are exceptions to the prohibited information that I shared with you before, and you can consider convictions and arrests prior to 7 years if you are hiring jobs supervising minors, dependent adults, and persons 65 years or older. You also can consider infractions such as a driving record where driving is a significant part of the job. For example, if a person is going to be delivering things, items, and that's part of the job, a big part of the job, then you can consider their driving record. There are state and federal preemptions, so state and federal laws preempt local laws, and the San Francisco Fair Chance Ordinance is a local law. So if you are in an industry where there is a federal or state law that requires background checks for certain jobs, then those positions are not covered under the Fair Chance Ordinance because the federal and state laws preempt our San Francisco local law. So examples of industries where there are state and federal preemptions would be financial services and the insurance industry. Now, starting to close up here, I want you to be clear about what the FCO does not do. The FCO does not require you to give preference to or to hire unqualified individuals with unresolved arrest or conviction records. The FCO does not limit your ability to choose the most qualified and appropriate candidate among the applicants, and it does not require employers to conduct a background check. And lastly, it does not prohibit employers from conducting a background check. It is about a compliant process. There's a lot of details. So certainly check out our toolkit and our videos to get best practices and more information. Now, this is our contact information for the Office of Labor Standards Enforcement, our direct number to the Fair Chance Ordinance hotline, as well as our email address. We have our OLSC website URL here, and if you'd like to directly go to the Fair Chance Ordinance website where you have a lot of resources available to you, please take a look here at this URL. I hope you understand a lot about the Fair Chance Ordinance. I invite you to take a look at our toolkit and our other videos in that series. Thank you and have a great day.